So, good afternoon, class. So, for this afternoon, I've decided to pre-record our discussions on Book 2 of the Labor Code so that all of you can actually access the recording at any time you wish to do so or during your availability, because I understand some of you are not available to for the conduct of of a synchronous class this afternoon. So, I've already pre-recorded the video presentation so you can access it anytime you wish to do so. And I hope that you will take note of all of the discussions that I'm going to do, as all of these will be included in your midterm exam. Okay, so I will now proceed with my presentation. So we are now on book 2 of the Labor Code. So National Manpower Development Program. So, Title 2, Training and Employment of Special Workers. Article 57, Statement of Objectives. This title aims to help meet the demand of the economy for trained manpower. Okay, and to establish a national apprenticeship program through the participation of employers, workers, and government and non-government agencies, and to establish apprenticeship standards for the protection of apprentices. So again, the law recognizes that also has to protect apprentices. So even if they are not formally employed yet, even if they are in the apprenticeship level, the apprentices are already provided with several rights under our labor code and all other special laws, which I will be discussing likewise in our video presentation this afternoon. Article 58. So please do not forget the definition of terms as used in this title. Apprenticeship means practical training on the job supplemented by theoretical instruction. Okay, so there are two facets of apprenticeship. It's a theoretical training and a practical training. The apprentice is a worker who is covered by a written apprenticeship agreement with an individual employer or any of the entities recognized under this chapter. An apprenticeable occupation means any trade, form of employment, or occupation which require more than 3 months of practical training on the job supplemented by related theoretical instruction. So take note, if the training or theoretical instruction exceeds 3 months, then this is considered as apprenticeship. And apprenticeship agreement is an employment contract wherein the employer binds himself to train the apprentice, and the apprentice in turn accepts the terms of training. Okay? So, Article 59, qualifications of apprentice. To qualify as an apprentice, a person shall be at least 14 years of age. But take note, we also have Republic Act 7610 on child abuse, the child abuse law of the Philippines, which prohibits the employment of children below 15 years old. So actually, here, the real age, the qualifying age to become an apprentice is actually 15 years of age, not 14 years of age, because the 14 years of age was considered in the implementing rules and regulations for the apprenticeship program. However, we should read the law in accordance as well in other related laws, such as, of course, the child abuse law, which prohibits the employment of children below 15 years of age. So here, the actual age or apprenticeable age is actually 15 years old, not 14. Possess vocational aptitude and capacity for appropriate tests, and possess the ability to comprehend and follow oral and written instructions. And of course, trade and industry associations may recommend to the Secretary of Labor appropriate educational requirements for different occupations. Okay, so they must have the following. To be an apprentice, they must have the following qualifications. The apprentice must be of 15 years of age, must possess vocational aptitude and capacity for appropriate tests, possess the ability to comprehend and follow oral and written instructions. Article 60, Employment of Apprentices. Only employers in highly technical industries may employ apprentices, and only in apprenticeable occupations approved by the Secretary of Labor. Okay? So take note of this one. Not all industries can actually employ apprentices. Only those highly technical industries. For example, I actually have a partnership with TESDA Isuzu. uh, um, test that trains the apprentices for theoretical training, of course, for example, in welding, electronics. So these are actually highly technical skills required in highly technical industries. So Tesla has a partnership with Isuzu, and Isuzu will be spending everything for the education of these apprentices. But once they graduate from the theoretical learning, they will be sent to the Isuzu plant or Isuzu factories, no, in somewhere in Luzon, and they will become apprentices. And after the apprenticeship program, if they pass the qualifications required by Isuzu, they can actually be absorbed by the company as a formal employee, but they will start as an apprentice first. Okay. Article 61, Contents of Apprenticeship Agreements. Apprenticeship agreements, including the wage rates of apprentices, shall conform to the rules issued by the Secretary of Labor and Employment. The period of apprenticeship shall not exceed 6 months. Apprenticeship agreement providing for wage rates below the minimum wage, which is in no case shall start below 75% of the applicable minimum wage, may be entered only in accordance with apprenticeship programs duly approved by the Secretary of Labor. The department shall develop standard model programs of apprenticeship. So take note, an employer who actually accepts apprentices in the industry, take note, number one, the employer must be a highly technical industry. And if they are allowed by the Department of Labor and Employment to have apprentices, then they can actually initially they can give at least 75% of the prevailing minimum wage. So but the apprenticeship program should be duly approved by the Department of Labor and Employment, and the apprenticeship program should not exceed 6 months. Okay. Article 62, Signing of Apprenticeship Agreement. Every apprenticeship agreement shall be signed by the employer or his agent, or by an authorized representative of any of the recognized organizations, associations, or groups by the apprentice. An apprenticeship agreement with a minor shall be signed in his behalf by his parent or guardian if the latter is not available, by an authorized representative of the Department of Labor, and the same shall be binding during its lifetime. Okay? Every apprenticeship agreement entered into under this title shall be ratified by the appropriate apprenticeship committees, if any, and a copy thereof shall be furnished both the employer and the apprentice. So take note of the requirements, okay? I reiterate, number one, um, uh, industries that are allowed to have apprentices should be technical or highly technical industries. The apprenticeship program should not exceed 6 months, and the wage that the apprentice will receive should not be less than 75% of the prevailing minimum wage of the region where they are to have their apprenticeship. So for example, they are from Tacloban City and they are sent to Bataan. Of course, the prevailing minimum wage that should be followed is the one that is considered in Bataan, not in Tacloban City. Okay? Article 63, Venue of Apprenticeship Program. Any firm, employer, group, or association, industry organization, or civic group wishing to organize an apprenticeship program may choose from any of the following apprenticeship schemes as the training venue for apprentice. Number one, apprenticeship conducted entirely by and within the sponsoring firm, establishment, or entity. So as I mentioned earlier, the apprentices can be sent to the sponsoring firm, the establishment, or entity. Apprenticeship entirely within the Department of Labor and Employment Training Center or other public training institutions. Okay, so it can be done in, of course, DOLE and other training institution. Initial training in trade fundamentals in a training center or any institution with subsequent actual work participation within the sponsoring firm or entity during the final stage of training. So this is what I mentioned between the program in partnership between TESDA and Isuzu. Okay, so the first few months, the first half of the 6-month period is spent at the TESDA, no? Here in Tacloban City, and after a few months, if they already have the proper theoretical training, they can be sent to the sponsoring firm, which is Isuzu. Article 64, sponsoring of apprenticeship program. Any of the apprenticeship schemes recognized herein may be undertaken or sponsored by a single employer or firm or by a group of association thereof or by a civic organization. Actual training of apprentices may be undertaken in the premises of the sponsoring employer in the case of individuals apprenticeship programs, in the premises of one or several designated firms in the case of programs sponsored by a group or association of employers or by civic organization, or in a Department of Labor and Employment Training Center or other public training institution. Article 65, investigation of violation of apprenticeship program. Upon complaint of any interested person or upon its own initiative, the appropriate agency of the Department of Labor and Employment or its authorized representative shall investigate any violation of an apprenticeship agreement pursuant to such rules and regulations as may be prescribed by the Secretary of Labor and Employment. And Article 66, appeal to the Secretary of Labor and Employment. The decision of the authorized agency of the Department of Labor and Employment may be appealed by any aggrieved person to the Secretary of Labor and Employment within 5 days from the receipt of the decision. The decision of the Secretary of Labor and Employment shall be final and executory. Article 67, exhaustion of administrative remedies. No person shall institute any action for the enforcement of any apprenticeship agreement or damages for breach of such agreement unless he has exhausted all available administrative remedies. Okay, so you cannot immediately go to court for the enforcement of the apprenticeship agreement or to recover damages for breach of a contract or breach of agreement. The law requires that you must go to the Department of Labor and Employment first, or it's any of its authorized representative or any of its appropriate agencies for the exhaustion of administrative remedy. So you have to file the administrative complaint first before you can proceed to judicial proceedings. Okay? So unless he has exhausted all administrative remedies. So if you have been able to exhaust all remedies already and you are still aggrieved by the decision of the Department of Labor and Employment, then that's the time you can go to the regular courts. This is now a condition precedent. Okay? Article 68, aptitude testing of applicants. Consonant with the minimum qualification of apprentice applicants required under this chapter, employers or entities with duly recognized apprenticeship programs shall have primary responsibility for providing appropriate aptitude tests in the selection of apprentices. Okay? If they do not have adequate facilities for the purpose, the Department of Labor and Employment shall perform the service free of charge. So that's why we have the NC1, NC2, NC3, NC4 national certificate coming from the TESDA. Article 69, responsibility for theoretical instruction. Supplementary theoretical instruction to apprentices in cases where the program is undertaken in the plant may be done by the employer. If the latter is not prepared to assume the responsibility, the same may be delegated to an appropriate government agency. So yun nga, if the employer does not have does not have the facilities for theoretical instructions, then it can actually tap the services of appropriate government agencies. Okay? So, for example nga, TESDA, because TESDA has the facilities for testing, uh, for theoretical instruction, so they can tap the TESDA for the conduct of theoretical instruction before they are put to an actual working scenario at the plant level of the firm. No? Article 70, voluntary organization of apprenticeship programs, exemptions. The organization of apprenticeship programs shall be primarily a voluntary undertaking by the employer. So the employers cannot actually be compelled to accept apprentices. But when national security or particular requirements of economic development so demand, the President of the Philippines may require compulsory training of apprentices in certain trades, occupation, jobs, or employment levels where shortage of trained manpower is deemed critical as determined by the Secretary of Labor. Appropriate rules in this connection shall be promulgated by the Secretary of Labor and Employment as the need arises. But actually now, looking into all the training centers, accredited test the training centers, this will no longer be a problem because actually there are so many test the accredited training centers available all over the Philippines, where services of foreign technicians are utilized by private companies in apprenticeable trades. Said companies are required to set up appropriate apprenticeship programs. Article 71, deductibility of training cost and additional deduction from taxable income. Take note, these are the incentives if the employer will accept apprentices, no, or will execute apprenticeship programs with the TESDA, because TESDA is primarily the government agency which oversees the apprenticeship program of the government. So on top of the exemption from the wage rates, prevailing wage rates, so long as it is not less than 75% of the prevailing wage rates, the employers can actually uh, get a deduction in the taxable income of one half of the value of labor training expenses incurred for developing the productivity and efficiency of apprentices shall be granted to the person or enterprise organizing an apprenticeship program, provided that program is duly recognized by the Department of Labor and Employment. Provided further that such deduction shall not exceed 10% of the direct labor wage, and provided finally that the person or enterprise who wishes to avail himself or itself of the incentive should pay his apprentices the minimum wage. Okay, so that's 50% actually of the labor training expenses, and 10% of the labor wage can be deducted in the taxable income of the employer. So imagine, no, 10% of the wages you can actually deduct it from your taxable income. So it's a big incentive actually for employers who would want to have apprenticeship programs. But take note, the apprenticeship program must be duly approved by the Department of Labor and Employment to avail of these benefits. Article 72, apprentices without compensation. The Secretary of Labor and Employment may authorize the hiring of apprentices without compensation whose training on the job is required by the school or training program curriculum or as requisite for graduation or board examination. So this one naman, it's on the job OJT, on the job training. So for OJT, no wages are required because it is required by the school or training program of the curriculum. So all of us had to, I believe, all of us who, of course, had to undergo OJT, no? So that's part of the training program for our curriculum. And yun nga, we cannot demand payment of wages for on-the-job training because at the end of the day, it's a requirement for graduating or taking the board exam. Now let's go to learners. So there's a big difference between an apprentice and a learner. Article 73, learners defined. Learners are persons hired as trainees in semi-skilled and other industrial occupation which are non-apprenticeable or which may be learned through practical training on the job in a relatively short period of time which shall not exceed 3 months. So take note, semi-skilled, not highly technical. When we talk about highly technical industries, that should be apprenticeship. But for semi-skilled and other industrial occupations, they can actually have trainees or learners. When learners may be hired, learners may be employed when no experienced workers are available. The employment of learners is necessary to prevent curtailment of employment opportunities, and the employment does not create unfair competition in terms of labor costs or impair or lower working standards. So take note, no, learners may be employed when no experienced workers are available. So this is a guarantee again. No, and the employment of learners is necessary to prevent curtailment of employment opportunities, and the employment does not create unfair competition in terms of labor costs or impair or lower working standards. Article 75, Learnership Agreement. Any employer desiring to employ learners shall enter into learnership agreement with them, which agreement shall include the names and addresses of learners. The duration of the learnership period which shall not exceed 3 months. So if learners not exceeding 3 months, for apprenticeship, it exceeds 3 months but not more than 6 months. The wages of or salary of the learners which shall begin at not less than 75% of the applicable minimum wage. So 75% as well. A commitment to employ the learners if they so desire as regular employees upon completion of the learnership. All learners who have been allowed or suffered to work during the first 2 months shall be deemed regular employees if training is terminated by the employer before the end of the stipulated period through no fault of the learner. So take note of that. No, so normally, learnership would take up to 3 months. But if the employer shall sever the employment or the learnership contract, and the learner has already rendered at least 2 months of employment, the learner will now be considered as a regular employee if the training is terminated, no, through no fault of the learner. So take note of that. That's another guarantee. Our apprentices, our learners are highly favored by the law, honestly. Because at the end of the day, okay, our labor code, if there's although we always hope for social justice, right? But then again, we go back to our to our principles of the labor law where it aims to bring workers at the same level as that of the employer, the same bargaining level. So that's why our labor code provides for these types of guarantees under the law. The learnership agreement shall be subject to inspection by the Secretary of Labor and Employment or his duly authorized representative. Article 76, learners in piecework. Learners employed in piecework or incentive rate jobs during the training period shall be paid in full for the work done. Article 77, penalty clause. Any violation of this chapter or its implementing rules and regulation shall be subject to general penalty clause provided for in this code. So take note of that. Okay, so there are penalties that can be prescribed, or there are penalties that can be meted to employers who do not follow the agreements that they have executed with apprentices and learners. Now let's go to chapter 3, handicapped workers. Article 78, definition. Handicapped workers are those whose earning capacity is impaired by age or physical or mental deficiency or injury. Article 79, When employable, handicapped workers may be employed when their employment is necessary to prevent curtailment of employment opportunities and when it does not create unfair competition and labor costs or impair or lower working standards. Article 80, Employment Agreement. Any employer who employs handicapped workers shall enter into an employment agreement with them, which agreement shall include the names and addresses of the handicapped workers to be employed. But take note, the second one here, the rate to be paid the handicapped worker shall not be less than 75% of the applicable minimum wage. This has already been repealed by the Magna Carta for persons with disabilities, which I will be discussing later. The duration of the employment period and the work to be performed by handicapped workers. The employment agreement shall be subject to inspection by the Secretary of Labor or his duly authorized representative. Article 81, Eligibility for Apprenticeship. Subject to the appropriate provision of this code, handicapped workers may be hired as apprentices or learners if their handicap is not such as to effectively impede the performance of job operations in their particular occupations for which they are hired. So, under the Magna Carta for persons with disabilities, I just highlighted the provisions applicable in our discussion. Section 5, as last updated by Republic Act 10524 in 2013, equal opportunity for employment. No person with disability shall be denied access to opportunities for suitable employment. A qualified employee with disability shall be subject to the same terms and conditions of employment and the same compensation, privileges, benefits, fringe benefits, incentive or allowances as qualified able-bodied person. So, if they are hired as an employee, then they should have the um same benefits received by all the other employees. Unless otherwise, the person with disability was actually hired as an apprentice or a learner, then that's when the 75% minimum wage rate uh, which shall apply. But then if they are hired as an employee without consideration whether they are an apprentice or a learner, then they should be paid the 100% minimum wage or whatever rate that the employer is giving to its employees, and it should not be below the regular minimum wage rates. At least 1% of all positions in all government agencies, offices, or corporations shall be reserved for persons with disability, provided that private corporations with more than 100 employees are encouraged to reserve at least 1% of all positions for persons with disabilities. Chapter 1, Discrimination and Employment. No entity, whether public or private, shall discriminate against a qualified disabled person by reason of disability in regard to job application procedures, the hiring, promotion, or discharge of employees, employee compensation, job training, and other terms, conditions, and privileges of employment. The following constitute acts of discrimination: limiting, segregating, or classifying a disabled applicant in such a manner that adversely affects his work opportunities, using qualification standards, employment tests, or other selection criteria that screen out or tend to screen out a disabled person unless such standards or tests or other selection criteria are shown to be job-related for the position on question and are consistent with the business necessity. Utilizing standards, criteria, or methods of administration that have the effect of discrimination on the basis of disability, perpetuate the discrimination of others who are subject to common administrative controls. Providing less compensation such as salary, wage, or other forms of remuneration or fringe benefits to a qualified disabled person by reason of his disability than the amount of which to which a non-disabled person performing the same work is entitled. Favoring a non-disabled employee over a qualified disabled employee with respect to promotion, training opportunities, study, and scholarship grants solely on account of the latter's disability, reassigning or transferring a disabled employee to a job or position he cannot perform by reason of his disability. Dismissing or terminating the services of a disabled person by reason of his disability, unless the employer can prove that he impairs the satisfactory performance of the work involved to the prejudice of the business entities, provided, however, that the employer first sought to provide reasonable accommodations for disabled persons, failing to select or administer in the effective manner employment tests which accurately reflect the skills, aptitude, or other factors of the disabled applicant or employee, that such test purports to measure rather than the impaired sensory, manual, or speaking skills of such applicant or if employee, if any, and excluding disabled persons from membership in labor unions or similar organizations. So again, disabled persons are protected by our law. And they are provided with several guarantees as well under the labor code. Okay? And of course, under the Magna Carta for persons with disabilities. Even under also in the Employees Compensation Program, the Occupational Safety and Health in the Workplace, which will be discussed in Book 4, also provides for several accommodations for persons with work-related disabilities or persons with disabilities. Okay? Now, let's go to the Republic Act number 7877 or the Anti-Sexual Harassment Act of 1995. Okay, so what is sexual harassment in work, education, training related sexual harassment? Sexual harassment in work, education, or training related sexual harassment, it is committed when an employer, take note of the enumerations, okay? Employer, teacher, or any person who has authority, influence, or moral ascendancy over another, demands, requests, or otherwise requires any sexual favors from the latter, regardless of whether the demand, request, or requirement for submission is accepted by by the object of the said act. Okay, so the demand, the request of the sexual favor doesn't necessarily have to be what accepted. So long as the demand was made, the request was made, the requirement of any sexual favor was made, then that could already tantamount to a violation of the Anti-Sexual Harassment Act of 1995. So, who may commit work, education, and training related sexual harassment? It may be the employer, it may be an employer, an employee, manager, or supervisor, agent of the employer, training instructor or professor, coach or trainer, any other person who has authority, influence, or moral is ascendancy over another in a work or training or education environment. Okay, so please take note of the following terms. Any person who has authority, influence, or moral ascendancy over another. Okay, take note of those terms because later I will discuss why. Okay? Any person who directs or induces another to commit any act of sexual harassment or who cooperates in the commission thereof by another without which it could not have been committed shall also be held liable under this act. So work-related or employment environment sexual harassment is committed by the concurrence of the following. The sexual favor is made as a condition in the hiring or in the employment, reemployment, or continued employment of individual, in granting said individual favorable compensation, terms, condition, promotion, or privileges, or the refusal to grant the sexual favor results in limiting, segregating, or classifying the employee, which in any way would discriminate, deprive, or diminish employment opportunities, or whether otherwise adversely affects the said employee. The above acts would impair the employee's rights or privileges under the labor laws. The above acts would result in intimidating, hostile, or offensive environment for the employee. The workplace sexual harassment occurs when a supervisor or an agent of an employer or any other person who has authority over another in a work environment imposes sexual favors in another, which creates in intimidating, hostile, or offensive environment for the latter. How is sexual harassment in education training environment committed? Sexual harassment in education or training environment is committed by the presence of any of the following. The sexual harassment is committed against one who is under the care, custody, or supervision of the employee offender. The sexual harassment is committed against one whose education, training, apprenticeship, or tutorship is entrusted to the offender. When a sexual favor is made a condition to giving of a passing grade, or the granting of honors and scholarship, or the payment of a stipend, allowance, or other benefits, privileges, or considerations, when the sexual advances result in an intimidating, hostile, or offensive uh, environment for the student, trainee, or apprentice. Okay? So now, what is the gravamen of the law? What does the law aims to prohibit? The gravamen of the offense is in sexual harassment is not actually the violence of employee sexuality, but the abuse of the power by the employer. That's why you would notice a person who can be held liable for sexual harassment is someone who is an employer, manager, or supervisor, agency of the employer, or agent of the employer, or any person who has what? Authority, influence, or moral ascendancy over another in a work or training education. So the grave ban of the law actually is the abuse of the power by a person who has moral ascendancy over the victim. Okay? What is the penalty or sanction of a person guilty of sexual harassment? A person found guilty of sexual harassment shall be penalized by imprisonment of not less than 1 month nor more than 6 months, or a fine of not less than 10,000 pesos nor more than 20,000 pesos, or both. May damages resulting from sexual harassment may be separately and independently instituted, yes, provided that nothing in this act shall preclude the victim of work, education, or training-related sexual harassment from instituting a separate and independent action for damages and other affirmative relief. Okay? So take note that the agreement of the anti-sexual harassment law is of course the abuse of power by a person who has moral ascendancy over the victim. Okay? Now let's go to Safe Spaces Act. So, Section 2, Declaration of Policies. It is the policy of the state to value the dignity of every human person and guarantee full respect for human rights. It is likewise the policy of the state to recognize the role of women in nation building and ensure the fundamental equality before the law of women and men. The state also recognizes that men and women must have equality, security, and safety not only in private but also in the streets, public spaces, online workplaces, and educational and training institutions. So here, the Safe Spaces Act actually expands the coverage of the anti-sexual harassment law. Okay? So, definition of terms, catcalling refers to unwanted remarks directed towards a person, commonly done in the form of wolf whistling and misogynistic, transphobic, homophobic, and sexist slurs. Employee refers to a person who, in exchange for remuneration, agrees to perform specified services for another person, whether natural or juridical, and whether private or public, who exercises fundamental control over the work regardless of the term or duration of agreement, provided that for the purposes of this law, a person who is detailed to an entity under the subcontracting or secondment agreement shall be considered an employee. Employer refers to a person who exercises control over an employee, provided that for the purpose of this act, the status or conditions of the latter's employment or engagement shall be disregarded. So whether the worker is a probationary worker, a project employee, a casual employee, it doesn't matter. He or she will still be considered as an employee under this act. Gender refers to a set of socially ascribed characteristics, norms, roles, attitudes, values, and expectations identifying the social behavior of men and women and the relations between them. Okay? So take note, gender-based online sexual harassment refers to an online conduct targeted at a particular person that causes or likely to cause another mental, emotional, or psychological distress and fear of personal safety, sexual harassment acts including unwanted sexual remarks and comments, threats, uploading or sharing of one's photos without consent, video and audio recording, cyber stalking, and online identity theft. Gender identity and or expression refers to the personal sense of identity as characterized, among others, by manner of clothing, inclination, and behavior in relation to masculine or feminine conventions. A person may have a male or female identity with physiological characteristics of the opposite sex, in which case this person is considered transgender. Okay, so here this law already considers the rights as well of all those considered as transgender or the LGBTQ uh, no? Community. Public spaces refers to street alleys, public parks, schools, buildings, malls, bars, restaurants, transportation terminals, public markets, spaces used as evacuation centers, government offices, public utility vehicles, as well as private vehicles covered by app-based transport network services, and other recreational spaces such as but not limited to cinema halls, theaters, and spas. Stalking refers to conduct directed to a person involving repeated visual or physical proximity, non-consensual communication, or a combination thereof that cause or will likely cause a person to fear for his own safety or the safety of others, or to suffer emotional distress. So, gender-based sexual harassment in the workplace. The crime of gender-based sexual harassment in the workplace includes the following: an act or series of acts involving any unwelcome sexual advances, requests, demands for favors, or any act of sexual nature, whether done verbally, physically, or through the use of technology such as text messaging or electronic mail, or through any other forms of information and communication system that has or could have a detrimental effect on the conditions of an individual's employment or education, job performance, or opportunities. A conduct of sexual nature and other conduct based on sex affecting the dignity of a person, which is unwelcome. Inyak nang ka nga, uy, matambok ka man, or sexy ka man hinduro, but then, bisa ka pag inyak nang nga sexy, ano, but then you felt, nakuan ka, to nga ginyak ka na mo. Then, you can actually file for safe spaces, for a violation of the Safe Spaces Act. Unreasonable and offensive to the recipient when done verbally, physically, or through the use of technology, such as text messaging or electronic mail, or through any form of information and communication system. So, here, the gravamen of the law is the act in itself already, the sexual harassment already. It's no longer about the abuse of power. So, as I mentioned earlier, the Safe Spaces Act already expanded the coverage of the anti-sexual harassment law. So, in the anti-sexual harassment law, the gravamen of the law is the abuse of power, no, the abuse of power of someone who has moral ascendancy. But for Safe Spaces Act, it is no longer required that the person who made the violation or committed the violations has moral ascendancy over the victim. What is only necessary is that the following has been committed. Letter C, a conduct that is unwelcome and pervasive and creates intimidating, hostile, or humiliating environment for the recipient, provided that the crime of gender-based sexual harassment may also be committed between peers and those committed to a superior officer or subordinate, or to a teacher by a student, or to a trainer by a trainee. Information and communication. So, again, between peers, na no? So, even by a subordinate to a superior employer, or to by a student to a teacher, or by a trainee to a trainer. So, because before, in the anti-sexual harassment, it was the trainee or the student or the subordinate who was the victim. But now, the officer or the superior officer, the teacher, or the trainer can be a victim because this law does no longer takes into consideration moral ascendancy, no, as an element of the crime. Information and communication system refers to a system of generating, sending, receiving, storing, or otherwise processing electronic data messages or electronic documents, and includes the computer system or other similar devices by or in which are recorded or stored, and any procedure related to the recording or storage of electronic data messages or electronic documents. So, duties of employers. Employers or other persons of authority, influence, or moral ascendancy in a workplace shall have the duty to prevent, deter, or punish the performance of acts of gender-based sexual harassment in the workplace. Towards this end, the employer or person of authority, influence, or moral ascendancy shall disseminate or post in conspicuous places a copy of this act to all persons in the workplace. Okay, so dapat may na postage of this act in the company premises. Provide measures to prevent gender-based sexual harassment in the workplace, such as the conduct of anti-sexual harassment seminars. Create an independent internal mechanism or a committee on decorum. Investigation to investigate and address complaints on gender-based sexual harassment. Adequately represent the management, the employees from the supervisory rank, the rank and file employees, and the union, if any. Designate a woman as its head, and not less than half of its members should be women. Okay, so there should be a committee on this one, and it should be headed by a woman. Be composed of members who should be impartial and not connected or related to the allegations or the alleged perpetrator. So this is now the CODI. This is a committee on decorum and investigation. Investigate and decide in the complaints within 10 days or less upon receipt thereof. Observe due process. Protect the complainant from retaliation. Guarantee confidentiality to the greatest extent possible. Provide and disseminate in consultation with all persons in the workplace a code of conduct or workplace policy which we shall expressly reiterate the prohibition of gender-based sexual harassment, describe the procedures of the internal mechanism created under Section 17 of this Act, and set administrative penalties. So there are penalties that can be provided or given to a person who could be found guilty of the violation of the Safe Spaces Act. This is on top, of course, of any judicial determination of such violation. So this is just an administrative pagka-office pahiya nga 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 case, then administrative pwede yan. But if it reaches the court, then now it becomes judicial process. Okay? So you can file either administrative, but of course, again, you have to exhaust the administrative remedies first. So you first file through your CODI or Committee in the Government Investigation, and then they have to act on it within 10 days. And of course, provide the necessary penalty on top of your rights to file a violation of the Safe Spaces Act in court. Okay? Section 18. Duties of employees and coworkers. Employees and coworkers shall have the duty to refrain from committing acts of gender-based harassment, discourage the conduct of gender-based sexual harassment in the workplace, provide emotional or social support to fellow employees, coworkers, colleagues, or peers who are victims of gender-based sexual harassment, report acts of gender-based sexual harassment witnessed in the workplace. Section 19, liability of employers. In addition to liabilities for committing acts of gender-based sexual harassment, employers may also be held responsible for non-implementation of their duties under Section 17 of this Act as provided in the penal provision. So take note, you have to, if you're an employer, you have to post in conspicuous places the copy of the Act and provide for a policy, company policy. Not taking action on reported acts of gender-based sexual harassment committed in the workplace. Any person who violates subsection A of this section shall, upon conviction, be penalized with a fine of not less than 5,000 pesos nor more than 10,000 pesos. Any person who violates subsection of this B of this section shall, upon conviction, be penalized with a fine not less than 10,000 pesos nor more than 15,000 pesos. Section 20, the Department of Labor and Employment for the private sector and the Civil Service Commission for the public sector shall conduct yearly spontaneous inspections to ensure compliance of employers and employees with their obligation under this act. So, gender-based sexual harassment in educational and training institutions, schools, whether public or private, shall designate an officer in charge to receive complaints regarding violation of this act and shall ensure that the victims are provided with gender-sensitive environment that is both respectful to the victim's needs and conducive to truth-telling. Every school must adopt and publish grievance procedures to facilitate the filing of complaints by students and faculty members. Even if an individual does not want to file a complaint or does not request that the school take any action on behalf of a student or faculty member, and the school authorities have knowledge or reasonably know about a possible or impending act of gender-based sexual harassment or sexual violence, the school should promptly investigate to determine the veracity of such information or sexual harassment information or knowledge in the circumstances under which the act of gender-based sexual harassment or sexual violence were committed and take appropriate steps to resolve the situation. If a school knows or reasonably should know about acts of gender-based sexual harassment or sexual violence being committed that creates a hostile environment, the school must take immediate action to eliminate the same acts, prevent their recurrence, and address their effects. So imagine, even if there was no complainant, so long as the school knows that there is a possible and impending act of sexual harassment, it must take the necessary or must make the necessary investigation. Once a perpetrator is found guilty, the educational institution may reserve the right to strip the diploma from the perpetrator or issue an expulsion order. The committee and the quorum and the investigation code of all educational institutions shall address gender-based sexual harassment and online sexual harassment in accordance with the rules and procedures contained in their code manual. So liability of school heads, in addition to liability of committing acts of gender-based sexual harassments, principals, school heads, teachers, instructors, professors, coaches, trainers, or any other person who has authority, influence, or moral ascendancy over another in an educational or training institution may also be held responsible for non-implementation of the duties under Section 22 of this Act as provided in the penal provisions, failure to act on reported acts of gender-based sexual harassment committed in the educational institution. Any person who violates subsection of this section shall, upon conviction, be penalized with a fine of not less than 5,000 pesos, nor more than 10,000 pesos. Any person who violates subsection B of this section shall, upon conviction, be penalized with a fine of not less than 10,000, nor more than 15,000 pesos. So imagine they did not, here, the person with moral ascendancy did not commit gender-based harassment. But then they have failed, letter A, they have failed to implement their duties under subsection 22, or they have failed to act on reports of acts of gender-based sexual harassment. Liability of students. Minor students who are found to have committed acts of gender-based sexual harassment shall only be held liable for administrative sanctions by the school as stated in their school handbook. Section 25, routine inspection. The Department of Education, the Commission on Higher Education, and the Technical Education and Skills Development Authority shall conduct regular spontaneous inspection to ensure compliance of social heads with their obligations under this act. So imagine nun, posting lang of the act in conspicuous places in the company could actually result to penalty. But then again, of course, there are still administrative remedies to that. It doesn't necessarily mean na pag nagkandak ka rin, if they conduct the inspection that you don't have the act, a copy of the act uh, posted in the conspicuous places in your company, doesn't necessarily mean that you will automatically be penalized. Okay, so you will be given opportunity to also to also comply. For example, if DOLE conducts an inspection in your company and you don't have the policies, you don't have a copy of the anti-sexual harassment law, or you don't have a copy of the Safe Spaces Act in posted in the conspicuous places in your company, it doesn't necessarily mean that the employer will automatically be fined with 5,000 pesos or 10,000 pesos. Of course, DOLE will give you an opportunity to comply with such requirements. Okay? So that's it for our book 2. So we've already discussed the major portions of book 1, but take note that we will include in our exams the introduction of our labor law, book 1 and book 2, and of course please include um anti-sexual harassment law. Also, please include Magna Carta for persons with disabilities. And of course, please also include the Safe Spaces Act in your studies. Okay, so our exams will be canonical, which means that most of it will be uh, on cases. However, take note that I might have 2 or 3 questions which would require you to enumerate. Okay, so take note of that. So of course, please highlight the provisions on trafficking in persons, also violation of uh, employment, or the violation of our employment for local and abroad. And of course, what do we mean when we say economic sabotage, committed by against whom, and how many perpetrators are required to constitute economic sabotage. So please do not forget all those things, and of course the guarantees. Okay, the guarantees, as I continuously reiterate, the guarantees are there because at the end of the day, our labor code highly favors, of course, our laborers, okay, our employees. But at the end of the day, we in as much as we want to temper, right? We want to address both sides, the employer and the employee sides. At the end of the day, our labor code all is favorable, of course, always to the employees. Okay, so anyway, that ends our discussion this afternoon. So it was just really, really quick. I took the liberty of recording my discussion so that everyone can watch the video presentation at their most convenient time. It was just really quick because these provisions of the law are not really case heavy. So why? Because honestly, in book 2, National Manpower Development Program has already been transferred to TESDA. Although for inspection purposes, DOLE is still there. No, the Department of Labor and Employment, through its secretary. Our secretary now is Benny Laguesma. He has the power, the visitorial powers, which he can delegate to the regional directors and the DOLE inspector. So under the visitorial powers, DOLE must always ensure that there is what compliance with the minimum wage standards, of course, and the minimum requirements, especially in the company policies as well. So very, very soon we will be also discussing in book 4 once we finish book 3. Book 3 is a little bit long, but book 4 is really quite extensive as well. But I will be inviting uh an expert on the occupational safety and health program. So you will find out what are these policies that the company are actually required to have in the conspicuous places of the company premises. So because there really are requirements for example, PTB policy, what else here? The Safe Spaces Act policy, anti-sexual harassment policy, BAUSI policy. So if you are an employer, you always have to maintain this. Okay, maintain a copy of this in the conspicuous places of your company, because at any time your company can be inspected by a DOLE inspector, and they will be looking for these policies. But then again, it doesn't necessarily mean that if you don't have these policies, you can immediately be what penalized, because there is a period for compliance on these things. And you can if you receive your notice of inspection, if you receive all your non-compliance, what you have to do is to comply all these things. If you don't have a safety officer, have someone be trained on basic occupational safety and health training. If you don't have the if you still don't have a policy on PTB, you can actually just download this. It's available. You can go to BWC, Bureau of Working Conditions, .dole.gov.ph to get a copy. You can just actually tailor this according to the needs of your company. Okay? So anyway, that's it for this afternoon. I will be for both sections. We will not be meeting next week. The next meeting will be during our exams. So good luck with your exams. As I mentioned earlier, there will be about 18. It's going to be canonical. I will focus more on cases, but there will be 18 questions, 15 canonical, and 3 enumeration. So you have to be ready for that. Okay, so anyway, good afternoon, class. I hope you are all well wherever you are, and I'll see you again during our exam. So thank you so much for listening to me this afternoon, and stay safe, stay healthy, and see you on your exams. Good luck. Bye for now.